Putting cars through their paces like this is what gives us the confidence to back our vehicles with the best warranty in the business. That's the Mazda way. Is there any other way?
It's a stomper semi. Yeah, it's got 10-wheel drive.
The 1983 Stomper Road King semis are coming through with working headlights and running lights. New trailers you can hitch on for the fun of it. Batteries not included. Plus, new heavy haulers for really big jobs.
10 wheels make them stompers go.
Stomper Road King semis, heavy haulers, and tractor trailers, each sold separately. Batteries not included. From Irwin.
Four little puppies in the pound, they're just waiting to be found.
These cute little pound puppies need someone to love them. They have no mama, no papa, not even a name. Would you like to adopt a pound puppy for your very own? You even get adoption papers that say he's really yours.
Little pound puppy, I found you. You love me, and I love you.
Will you be my friend forever?
Pound puppies. Each one is different. Sold separately from Irwin.
Tefal Durabase Imperial is the Super T Plus non-stick coating and the superb Durabase red exterior enamel. Now Tefal offers you a specially priced 7-piece set that includes 1 fry pan and 3 saucepans with stainless steel lids, featuring practical steam vents. Extra resistant, the attractive and easy to clean Tefal Imperial set is 1 fry pan and 3 saucepans with their lids. Available at a very special price. Also look for the Tefal Imperial 2 fry pan set and save 25% or more from the suggested retail price.
You take charge, people taking charge.
And you've made Chevy Cavalier our fastest growing subcompact.
Taking charge in your own way. You're taking charge with Chevrolet.
84 Chevy Cavalier. There's one just right for you. Coupe, sedan, hatchback, or wagon. And a down-to-earth Chevy price from only $72.76. Chevy Cavalier from $72.76.
Price the way you want to pay. You're taking charge with Chevrolet.
Firebird. Feel the rush of pure excitement. Thrill to one of the most sensational cars of our times. Take out a Firebird and take on the world. Pontiac builds excitement.
Everybody has their own reasons for drinking responsibly. For taking a cab or a bus out so there's no need to make a decision later. For realizing that a drink has a right time and a right place. And remembering that there are people who depend on them. Everybody has their own reasons. Think about yours.
Len's Mill Store has gotten very serious about saving you money. Len's Mill Store has made a major purchase. 5 tractor-trailer loads of superior quality Wabasso sheets. Over 200 styles and patterns at incredible savings. Twin size from $8, double from $10, queen from $12, and king size from just $14. All 5 locations of Len's Mill Store with superior quality Wabasso sheets. Len's Mill Store. We've got the sheets.
Join Oopsie the Clown and his special guests on Big Top Talent, Sundays at 12 noon on CKCO TV.
Pick up a box of ABC detergent, you pick up a great value. You could save up to 20% over a leading brand. ABC is even challenging people to tell the difference between a wash done in ABC and one done in the same leading higher price detergent.
Well, they both look clean and white.
I can't see a difference.
There is one difference. You could save up to 20% with ABC. And today, 20% is a lot of money. Why pay more? Buy ABC.
If I were in charge of Speedy Muffler King, I'd invent the best guarantee in a business.
Introducing the exclusive Speedy 110% satisfaction guarantee. Get your money back plus 10% if you're not satisfied.
You can't beat the best.
You can drive your car when you've got a bite. You ate an extra piece of pizza last night. You stayed inside on a beautiful day. watching TV, but you're okay. You may not be a Hollywood star, but we love you for what you are. We love you just the way you are.
Sugar-free Canada Dry. A tingly burst of ginger and a great light taste. Wouldn't you love one now?
Eaton's Trans-Canada sale is the one sale with more savings and more selection for more people than any other sale all season. With so many outstanding buys, it's no wonder everyone waits for Eaton's Trans-Canada sale.
You spend a lot of time shopping for the right home. Shouldn't you be just as careful about shopping for the right mortgage? At the Commerce, you can choose the mortgage best suited to your needs.
Right, Ann. The Commerce offers variable rate and fixed rate mortgages with terms from 1 to 5 years. Plus a new prepayment plan with the best overall options of any Canadian bank.
More Canadian families than ever before count on the Commerce for their mortgages. You can count on the Commerce.
Get a university degree paid for. Study history, physics, medicine, engineering, name it. Join students like these who are getting a university degree, a salary, and that important first job, all paid for by the Canadian Armed Forces. Want a degree and a future? We're under recruiting in the Yellow Pages. Choose a career. Live the adventure.
Leading the way with breaking news.
A Claremont County man accused of murdering his 3 young sons appeared before a judge today, one day after he was indicted on 21 charges. Thanks for joining us here at noon. I'm Stephen Albritton. Investigators say Chad Doerman planned the murders and then executed his plan last week. WLWT News 5's Karen Johnson is live in Batavia with more on what happened this morning. Karen?
Good afternoon, Stephen. Chad Doerman entered a not guilty plea this morning here in Claremont County, which is standard during this stage of the process. He faces 21 counts, including 9 charges of aggravated murder. This morning, prosecutors also revealed more details about the case, and I just want to warn people that the details involving 7-year-old Clayton, 4-year-old Hunter, and 3-year-old Chase are extremely graphic. Doerman is accused of shooting all 3 last week at their house on Laurel Lindale Road in Monroe Township. And this morning in court, prosecutors said he killed 4-year-old Hunter first, then shot 7-year-old Clayton after he ran into a field behind the home. They say the youngest, Chase, was the last to be killed after Doerman ripped him from his mother's arms.
This is a death penalty case, and my goal is to have this man executed for slaughtering these 3 little boys. It is an incomprehensible act of horror that he perpetrated on this family. So again, that is my most important focus right now, is to ensure that they're protected and they're safe. And my hope and wish and prayer is that someday they will be able to find peace.
And today, the judge ordered Doerman be held here in the Claremont County Jail without bond. If convicted, he does face the death penalty. He is scheduled to return to court July 5th. Reporting live in Batavia, Karen Johnson, WLWT News 5.
Karen, just such heartbreaking details coming out of that arraignment this morning. Now, we're hearing that you were able to speak with the family members of those boys.
Yeah, I spoke to the aunt this morning after the hearing, and she just wanted to get across some details about the funeral. We know the visitation and the celebration of life is what it's being called, is set for Monday at First Baptist Church of Glen SD. She wanted the public to know that it is open to the public. She says there's going to be guest books scattered throughout the church, and they're encouraging people to share any stories they may have of the boys. She says that's one thing that is getting her sister through all of this, is just hearing the happy stories. And also the family is asking if you attend to wear bright colors, because again, they want to remember the happy times and they want this to be a celebration of life.
Celebration for Clayton, Hunter, and Chase. Karen Johnson live for us this morning. Karen, thank you so much. We do appreciate it.
Welcome, everyone. Oh, man. That's a lot. That's a lot. So yeah, this morning there was a hearing for Chad Doerman, and he entered a not guilty plea, which I did not think was going to happen until the scheduled hearing, which was Monday. So I'm guessing what happened was they put the indictment through last night or yesterday, and once the indictment went through, then they scheduled the hearing immediately, I would assume. I think that's how it works. And he entered a not guilty plea. Some of you guys are like, well, how can he actually, most of us are going, how can this guy possibly enter a not guilty plea? And then, you know, I've had exchanges with people in comment sections and whatnot, where, you know, they'll say, well, there's evidence that he planned it. There's evidence that he planned this, and that, I mean, the thing is there's not, that we know of yet. I'm not saying there isn't evidence of this. I'm saying we have not been made aware of this evidence. I think it's also safe to assume, in the defense of those people who are saying that, I will say this, as far as the benefit of the doubt goes, and the next hearing is now July 5th. Thank you, Cherry. I appreciate that. So the thing is, yeah, I'm going to get to that, Team Brittany, I promise. Because actually a lot of this, believe it or not, when you move your anger to the side a little bit, kind of brush your anger a little bit to the side, things will make a little bit more sense. I promise. We're gonna do that with this stream. This stream is going to be about making the most sense of what's going on. And you know, again, I'm not an attorney. I'm just, you know, somebody who's followed these cases and just like you guys. And, you know, no, there is no official motive known just yet. So we don't have, we don't know what law enforcement has. We know that law enforcement and the prosecutor, all we know, honestly, is that the prosecutor stated in the original arraignment that that he planned this, and that he confessed to it, that he admitted to doing so, to murdering these three boys. And that is not evidence. Now, like I said, in the defense of those people that I've spoken to in comment sections and whatnot, very respectful exchanges. It's not like we got in arguments, but because I understand the anger, and I understand people going, how? We only know that the prosecution said these things, but again, like I was getting at, in defense of the people that I was speaking with, I think it's safe to say, personally, my opinion is, I don't think a prosecutor would say these things in a court of law unless he knew that he could prove these things. So I have faith in the justice system. I have faith in this prosecutor. I have faith in these investigators that they're going to do a very swift but tactful job in prosecuting this person. Now, here's the thing. We don't have any idea what kind of case the prosecution has, other than the fact that it's just undeniable that this man is responsible, considering the 911 call, considering the 2 911 calls that we heard, considering the what we were hearing, the mother of these 3 boys screaming in such a horrific manner, that, you know, expressing the horror that she was experiencing. It's I don't think it's 27 counts. I think it's only 21. I think it's only 21 charges. I'm going to go over that indictment, by the way. I have that here. I did post it in community, the link to it, so anybody can access the indictment, the official indictment that came out yesterday. And yes, 21 charges. I don't think that I think that the prosecution is definitely trying to create something airtight, just anything that they could throw at this guy to make sure that he is buried under the jail, if not executed. And as we heard, this prosecutor is absolutely looking for the death penalty, which brings me to why he would plead not guilty. That tells me, based on what we heard that prosecutor say in that last footage that we watched, based on watching that, I don't think there's any deals on the table. With Chris Watts, it was, okay, well, we'll take the death penalty off the table if you plead guilty, and then you just spend the rest of your life in jail. I don't think that that's what they're looking for here in Ohio. I don't think that that's what they're willing to settle for. And when you, when a prosecutor tells you, hey, listen, oh, thank you, Cash. I appreciate that. When a prosecutor sits you down and goes, well, here's how this is going to go. I'm seeking the death penalty. I don't care what you do or say. Nothing is going. I am going to make sure, I'm going to spend my immediate time and energy. My existence is going to be dedicated to making sure that you fry, period. And that's the vibe I'm getting from this prosecutor, which, if that is the case, nobody in their right mind would just plead guilty. Nobody would. Most anybody, as far as applying their instincts for survival, what they would do is take their chances. Maybe they can get out of it. Maybe they can beat the case. Maybe they can beat it on a technicality. It would be foolish to not plead not guilty. It would be foolish to plead guilty when your life is on the line. Even if you plead guilty, they're going to give you the death penalty. The prosecution is going to seek the death penalty, even if you plead guilty. So it just, there's nothing to lose here. Now, does it suck? Do I think it's shit that these loved ones of these 3 boys are going to have to go through the trauma of a trial? Absolutely. I think it sucks. I think it's horrible. But the fact of the matter is, you know, because I was thinking maybe he's going to try the insanity thing, and that's probably going to be his defense: temporary insanity, temporary derangement, whatever. I'm of the opinion that that's somewhere where he's going to go with that. That's the only chance that he has, based on the little that we know so far. Again, we don't know what evidence they have. I still want to see that police interrogation video. I know that it's there. I know it exists. So it's just a matter of time. And I hate to have to wait till trial for that to happen, but this is going to go to trial. But I have a feeling that this is going to be one of the quickest, most swiftest trials that ever took place. And Amy M, I'm not going to disagree with you, but I'm going to show you guys something here, okay? Because again, folks, we don't have all the facts. It's real easy for us to just go, well, he's a sociopathic piece of shit, and lock him up, you know, give him the needle. That's it, right? Very, very easy to do that considering how heinous what he did was. I'm with you. But let's consider some things. These are some things that I kind of hinted to. These are some things that I kind of hinted to before. Now, before I actually go into that, let me just go over, because Cherry is sharing some of these details, but let's go over all of these charges real quick. So this is the official indictment of Chad Christopher Doerman. So on or about June 15th, 2023 is the date of the offense. Chad Christopher Doerman, on or about June 15th, 2023 at the county of Clement, aforesaid, did purposely and with prior calculation and design cause the death of, and of course they redacted the children's names are redacted in violation of Ohio Revised Code. Victim under age 13 murder specifications. Grand jurors further find and specify that the offender in the commission of the offense purposefully caused the death of another who was under 13 years of age at the time of the commission of the offense, and either the offender was the principal offender in the commission of the offense, or if not the principal offender, committed the offense with prior calculation and design. Now most of this stuff is just, I mean, I'm not an attorney. I don't know really how to read a lot of these things and how to translate them because I don't really fully understand them. But we'll do our best just to try to make the best sense of it and use our common sense. So course of conduct specifications. So these are certain, however this works, they're showing all of these specifications as far as the specifics, basically, in these charges. Killing of or attempt to kill two or more persons by the offender. Felony murder specification. The offense at bar was committed while the offender was attempting to commit, or fleeing immediately after committing or attempting to commit kidnapping, and either the offender was the principal offender in the commission of the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. And then the firearm specification, 3 year. I don't know. Is that a 3 year, like, is that a what do you call it? Oh God, why is that slipping my mind right now? Statute of limitations, 3 years. Is that what that is? I don't know. It probably has nothing to do. I sat here trying to think of that. It's probably wrong. But it goes on. The firearm specification, the offense displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense. Specification or for forfeiture of a weapon. The grand jurors further find and specify that Chad Christopher Doerman is the owner and or possessor of a Marlin Model HC 22 rifle, which was contraband and or property derived from or through the commission of facilitation of the offense, and or was an instrumentally the offender used or intended to use in the commission of facilitation of the offense. The offense is contrary to the form of the statute, in such case made and provide and against the peace and dignity of the state of Ohio. Yeah, I don't know what's going on with the YouTube chat, man. it's not the only, this isn't the only place I've seen it, but it happens to me too when I've got YouTube pulled up here. It's pretty annoying because I really want to be able to acknowledge like new members for more than 1 month who leave comments. I can't acknowledge those because they don't show up in my StreamYard chat and I can't highlight them. And I count on my YouTube chat to be able to see them when they happen. And I'm really sorry that I can't see them if the chat is glitching. So if I miss those guys, I do apologize, and I do appreciate all of the memberships. Just if I miss acknowledging them, I apologize. So there are more of these specifications, and they're kind of all the same thing over and over again, I guess, for each offense, maybe. But these are the specifications. So count 1 is aggravated murder, count 2 aggravated murder, count 3 aggravated murder, count 4 aggravated murder, count 5 aggravated murder, count 6 aggravated murder, count 7 aggravated murder, count 8 aggravated murder, count 9 aggravated murder. Now I'm curious about this. Count 10 kidnapping, which I find interesting. Count 11 kidnapping, count 12 kidnapping, count 13 kidnapping, count 14 kidnapping, count 15 kidnapping, count 16 kidnapping, count 17 kidnapping, count 18 felonious assault, sorry, count 19 felonious assault, count 20 felonious assault, count 21 felonious assault. Oh man. Yeah. So, and there's a firearm specification in all of these. So none of this indictment does not have like an actual account for what's taken place. This is not a probable cause affidavit, so it's not going to have the reasons for their justification for arresting him. So one neighbor said that, Amy M. And you know, let's get into this because I'm glad you brought this up. So neighbor said he was abusive. Okay. There's one particular aspect about this entire case, besides the obvious, which is 3 young boys lost their lives at the hands of the person who they were supposed to trust most in this world. The one person who's supposed to truly teach them and set an example for how to be men and succeed in this world through being a scrupulous person. The one person who's supposed to teach them, you know, the difference between being a man and being a coward, being a shitbag. Besides those obvious things, where is the history of being a bad father? Where is it? Let me show you guys something here real quick. Because this is what's been bothering me. This man, by all accounts, seems to be a great father until this incident and what happens. Very little that we know so far, but I'm just not accepting the whole he's a sociopathic piece of shit. I'm not accepting that just yet. I'm not ready to accept that just yet because I'm not seeing any evidence other than this horrible crime where there are different possibilities as to why he could have engaged in this behavior all of the sudden when it just doesn't mesh with the rest of his behavior prior. So there's something very, very strange about this.
A pattern of general violence. We filed an open records request with the Claremont County Communications Center to see if there had been sheriff's calls related to Chad Doerman or at his address over the past 3 years. Our answer came Wednesday in the form of an Excel document. The Communications Center has only dispatched the sheriff to the Doerman home 3 times since 2020, and that was all last week when the 3 boys were shot to death. Our search of court records show.
See, that's very interesting. So right there, according to records, the only time 911 has ever been dispatched to that home was during this incident that took place on the 15th. That's interesting to me. That's very interesting to me.
Show only traffic violations in Claremont County, with the exception of a criminal damaging complaint when Doerman was 18, and there was a domestic violence case 2 years later showing he choked his dad. Both of those cases were dismissed. Second, did we see child neglect or abuse? We interviewed a neighbor who said he saw Doerman lose his temper with his children.
I tell you, he tossed a couple of them around in the yard one day.
We filed with Claremont County Children's.
See, I'm just not sold on this guy's credibility just yet. Because he's the only one. All of a sudden, I mean, this guy's the only one that ever saw anything? Why is he the only one? And why didn't he call 911? Why didn't he report? See, that's my thing right there, is why didn't this good Samaritan neighbor who sees all and is so quick to talk about this guy as being abusive, but yet he's never lifted a finger to help these children from this monster that he seems to have known lived across the street from him? Why didn't he ever report them? Why didn't he ever report them? Why didn't he ever call 911? Why didn't he ever call CPS? Because, I mean, dude, if you're not going to do shit to actually lift a finger to do something to help, but then you're going to fucking jump in front of a TV camera and say all this shit, it just doesn't look right. You know what I mean? It does not look right to me, dude.
Protective Services a records request to see if there were any referrals, requests, complaints, or calls referring to Chad Doerman or at his address. The organization has a reasonable amount of time to produce those documents. Doerman certainly appears to be like any other dad on his Facebook page. He had posted a picture of he and his kids just 4 days before the shooting on Father's Day. Third, was there
okay, now the Facebook page I've seen. The Facebook page I've seen, it's basically set to most of the private settings. Like, you could see profile pictures that he set, and that's it. But you can't see anything else. So who knows what he posted? You know what I mean? Like, people who know him might come forward and say something, but I feel like they would have done so by now. You know what I mean? Somebody would have come forward and been like, look at these shady memes that this guy posts. Look at this, look at these, misogynistic posts that this guy, you know what I mean? Anybody would have jumped all over the opportunity to make this guy out to be a monster already. But yet we're not seeing anything from his Facebook page other than pictures of him with his boys. other than him being clearly an active dad with his 3 boys who look very happy.
A pattern of financial issues. We searched the auditor's website and found Doerman had purchased his converted manufactured home on 3 acres in 2016 for $75,000. Usually, if there were mortgage issues, you would see a lapse in property tax payments.
Okay. Now we know the guy's not a deadbeat, right? Maybe he was. Maybe mom paid all the bills. I mean, that's possible. But usually when you have this narcissistic control freak asshole, right? And here, I'm glad you pointed Chris Watts out. Chris Watts was a great father until he wasn't. True. Agreed. Same with this guy, in my opinion, so far. At least the evidence dictates this, right? But Chris Watts and Shanann Ruchek, they were up to their ears in debt. They were living way beyond their means. Everyone knows that. And that could have added to some of the stress. The money could have added to some of the stress, but these people were not, there's nothing to indicate so far that they were struggling financially in the slightest bit. This guy bought a house in 2016 for a very cheap price. $75,000 is not expensive for a house. Even in 2016, it is not expensive for a house. And I would imagine a lot of that has to do with the area that they're living in. But to have a house, a 3-bedroom house, and not have any problems, I mean, there doesn't seem to be any financial issues, no remortgaging of the house, nothing. I mean, this is telling, no?
The Doermans were up to date through 2023. Lastly, was there evidence of mental illness?
What the research shows is that people who've engaged, at least in mass shootings, have almost always had multiple issues that they were upset about, and then a crisis that they couldn't manage.
This appears to be sociopathic behavior, yet in court we see him what appear to be real tears. We see him break down and cry, which doesn't really go along with that.
And the key word that you use there is seems. And without doing formal assessments, without knowing someone better, we wouldn't be able to know.
Right.
Yeah, that was Diane Wright with great.
So what am I taking from that exchange right there? Usually when it comes to an incident like this, there's some sort of traumatic event that triggers these people and they have trouble managing the trauma. And then they end up doing something irrational. People generally, like mass shooters, people who end up behaving in this manner usually have some sort of mental health history, some sort of issues. Now, it's quite possible that he may have never even saw anybody and was diagnosed. Who knows? Maybe he just was the kind of guy that was like, I'm not going to see a shrink. No. I mean, we don't know. But there's nothing on record that says that this man had mental health issues.
Greater Cincinnati Behavioral Health Services, we certainly are not going to have access to any mental health records, if any exist at all. Now, we do know through our records request that there is no current documents that show the sheriff arrested Doerman or put a 72-hour psych hold on him. And we did just get an answer to our records request asking Claremont County Children Protective Services whether it has received complaints related to Doerman. And the answer is there are no records responsive to your request.
All right,
Paula.
David,
so right there, no records, not even any CPS records. It's not like CPS, they answered him back and said, well, we're not allowed to give out that information. They're saying there are no records. You're asking for records, but we don't have any. There is no record of any complaints of Chad Doerman being abusive, neglectful, nothing towards these kids. Not one CPS complaint. No record of a CPS complaint. Why did this happen? Because at this point, people, my interest in this is exactly what it was from the start. It was, wait a minute, this guy doesn't seem like a bad father. Why would he do this? This doesn't make any sense. And now at this point, since there are investigative professional journalists that are asking the same exact questions that I was asking, that makes me feel like there's validity to what I'm asking. There's validity to my questions. Why did this person do this? Does he actually have a defense? That's what I'm really curious about. Does this man actually have a defense? Is he just pleading not guilty because they're seeking the death penalty and there's no way out of it? Whether he pleads guilty or not guilty, they're seeking the death penalty as a sentence. So is he pleading not guilty just to have a fighting chance to save his life? Or does he actually have a defense? How do you know that, Donna Bolton? How do you know that? See, this is what we call a rumor right here. This is what we call a rumor. We don't like those here in my chat. And yes, it's a standard plea. It's a standard plea when seeking the death penalty. Of course it is. Okay, Nurse Bev. I mean, that's true, but I mean, what if we thought that way about every single person? That we don't even have as much information on. What if we thought that way about every single person? Well, they're probably still a bastard. Nobody reported them. I mean, that's possible. But I'm not even really willing to say that that's likely. Yeah, I mean, I agree, Nicole B. That's a really dumb way to avoid child support. Like, that's not how you avoid child support. Just so you know. It's not how to do it. Dietz, I'm thinking that he'll probably go with a temporary insanity plea. I mean, think about it. Like, if the defense gets enough character witnesses to take the stand and go, I can't make sense of this. If there's enough people, if the fact that he just never, if the reason why he was never reported on anything to CPS or 911 was never called, if the reason why he was never reported was simply because he never engaged in any bad behavior as a bad father, if that turns out to be the reason, then there's going to be plenty of character witnesses that the defense can bring up. The defense can bring up plenty of character witnesses that are going to say that he was a great father. None of this makes sense. It doesn't add up. This is crazy. Because I mean, I I'm definitely of the opinion that they can absolutely. I mean, I don't think that the prosecution would say the things that they said unless they felt that they could convince a jury of their case. But the defense, again, it's a standard plea when they're seeking the death penalty. It's a standard plea, I imagine, simply because it gives them a fighting chance. Right. I mean, did he have a drinking problem? I don't know. Oh, this guy's got any brains. If this defense attorney's got any brains, he's not calling Dorothy Lewis as a witness. Right. I mean, well, I heard the rumor that he drank to excess, but that only came from the neighbor. I only heard that from the neighbor who said that he saw him tossing the kids around the front yard. The neighbor that, never reported it. The neighbor who claims that he witnessed child abuse and didn't report it. So how good is that guy's credibility to you? I know how it stands with me, but how good is the credibility of a guy who witnessed child abuse and waits till he's in front of a camera and waits till three boys, those very same boys that he witnessed being abused in their front yard, after they get killed by their own father with a rifle? How strong is that guy's credibility? After it's way too late and these three boys were murdered by the hands of this person who he says he witnessed abuse these boys, and he never reported it. How credible is that guy to me? How credible is he to you? Because he's not very credible to me. I'll tell you that right now. Why would the neighbor lie? Because so he could be on fucking TV. People lie all the fucking time. Why does everyone in the Summer Wells case seem to be lying? Why does everybody have conflicting bullshit stories? Completely agree. I could give a fuck about that guy and what he has to say. That dude has no credibility with me at all whatsoever. I don't give a fuck what that guy has to say. Exactly. Sometimes people just fucking lie just so they can fucking lie, But either the guy's a liar or he's a fucking shitbag who could have at least done something to try to save those kids' lives. I'm not saying he's responsible for what happened. I'm saying it's a little late to get in front of a fucking TV camera and talk about how you witnessed this man abuse these kids and you didn't do shit about it. But you're going to tell the world on TV, you're not going to tell the proper authorities, get the fuck out of my face, dude. You don't have any credibility with me. I'm not saying the guy's a liar, but I'm saying he's either a liar or a shitbag or both.
I appreciate the fact that you are searching so hard for answers. I think all of us will just never really understand this. It should also be noted that at this point, Doerman has only been arrested for murdering his children. He has not yet been indicted, and of course, innocent until proven guilty. We do know the grand jury meets Thursdays in Claremont County, so it's possible we'll know more about an indictment tomorrow or Friday.
Which is what happened. I'm going to play this one more time because I really want you guys. This is the kind of stuff that when we are approaching a trial, okay, when we are approaching a trial or we're following a case, these facts matter. And this was done by an actual investigative journalist. This is not some fucking YouTuber who with a 1992 fucking printout of a press pass. Okay, this is an actual investigative journalist who went looking for answers to try to make sense of this.
First, was there a pattern of general violence? We filed an open records request with the Claremont County Communications Center to see if there had been sheriff's calls related to Chad Doerman or at his address over the past 3 years. Our answer came Wednesday in the form of an Excel document. The Communications Center has only dispatched the sheriff to the Doerman home 3 times since 2020, and that was all last week when the 3 boys were shot to death. Our search of court records show only traffic violations in Claremont County, with the exception of a criminal damaging complaint when Doerman was 18, and there was a domestic violence case 2 years later showing he choked his dad. Both of those cases were dismissed. Second, did we see child neglect or abuse? We interviewed a neighbor who said he saw Doerman lose his temper with his children.
I tell you, he tossed a couple of them around in the yard one day.
We filed with Claremont County.
So why didn't you call the cops, dude? Why didn't you call CPS?
Children's Protective Services a records request to see if there were any referrals, requests, complaints, or calls referring to Chad Doerman or at his address. The organization has a reasonable amount of time to produce those documents. Doerman certainly appears to be like any other dad on his Facebook page. He had posted a picture of he and his kids just 4 days before the shooting on Father's Day. Third, was there a pattern of financial issues? We searched the auditor's website and found Doerman had purchased his converted manufactured home on 3 acres in 2016 for $75,000. Usually, if there were mortgage issues, you would see a lapse in property tax payments. The Doermans were up to date through 2023. Lastly, was there evidence of mental illness?
What the research shows is that people who've engaged, at least in mass shootings, have almost
like you're likely not going to pay your property taxes and not pay your mortgage. You know what I mean? Like it doesn't add up. These people seem to be financially fine. Maybe not like necessarily well off, but that there's no evidence of any financial issues is my point.
almost always had multiple issues that they were upset about, and then a crisis that they couldn't manage.
This appears to be sociopathic behavior, yet in court we see him what appear to be real tears. We see him break down and cry, which doesn't really go along with that.
And the key word that you used there is seems. And without doing formal assessments, without knowing someone better, we wouldn't be able to know.
So that right there, here you have a mental health expert who this investigative journalist spoke with, and she's on camera and she's telling you right now that you cannot assess someone as a sociopath and you without sitting down with them and actually, analyzing them. That takes time. That takes, you're not going to sit with them one time and then come to this conclusion that they're a sociopath, much less just take this action that you would imagine it would only a sociopath would be capable of, such as killing their 3 sons. That seems sociopathic, but without knowing all of the facts, is what she's saying, you cannot come to that conclusion. You cannot logically come to that conclusion. She's saying, even as a mental health expert, without doing a serious formal assessment of that person, you cannot come to that conclusion. Therefore, if this mental health expert can't do it, how in the fuck is a bunch of people on YouTube going to be able to do it? So what are we talking about here? And the fact is that we just don't know. None of this is coming together like, oh, okay. None of that's happening yet. As far as the why. Not one thing is ringing bells going, oh shit, that makes sense. That adds up. Nothing is happening in that regard.
Yeah, that was Diane Wright with Greater Cincinnati Behavioral Health Services. We certainly are not going to have access to any mental health records, if any exist at all. Now, we do know through our records request that there is no current documents that show the sheriff arrested Doerman or put a 72-hour psych hold on him. And we did just get an answer to our records request asking Claremont County Children Protective Services whether it has received complaints related to Doerman. And the answer is there are no records responsive to your request. Paula?
David, I appreciate the fact that you are searching so hard for answers. I think all of us will just never really understand this. It should also be noted that at this point, Doerman has only been arrested for murdering his children. He has not yet been indicted, and of course, innocent until proven guilty. We do know the grand jury meets Thursdays in Claremont County, so it's possible we'll know more about an indictment tomorrow or Friday.
And just to catch you guys up on everything that's happening here.
We're breaking back into coverage as right now. Chad Doerman is back in court. Yesterday, he was facing even more charges, 21 additional charges for the murder of his 3 boys. We're going to take you live out to the courtroom right now as the judge has just walked into the room. Chad Doerman, listening to the judge right now.
All right, now this is the entire, get comfortable guys, because this is going to be the entire hearing that took place this morning, okay?
We're on the record. All right, the court's going to call 23.
And I'm sorry about the sound. It is the best that we've got. This was not mic'd for for being televised. This was the sound is designed so the people in the courtroom can hear each other, not so we at home can hear them. So I do apologize for the sound.
CR 0407, State of Ohio versus Chad C. Doerman. Are you Mr. Doerman?
Yes, sir.
All right, Mr. Myers, Greg Myers is present as well.
Yes.
Mr. Stephen Haynes is present. Mr. Mark DeColby, prosecutor for the county. Ms. Laura Barron Allen, and Mr. Clay Clark, correct?
Correct.
All right, let's make that record. Ms. Marcone is the court reporter today, and pursuant to Ohio Rules of Appellate Procedure 9A and B, the court is going to swear you in, Ms. Marcone. You would please raise your right hand. I, Vicky L. Marcone, having been duly appointed as an official court reporter for the Common Police Court of Claremont County, Ohio, do solemnly swear and promise to uphold the Constitution and the laws of the United States of America and the Constitution and laws of the State of Ohio, and to faithfully and partially discharge the official duties of the court reporter. Would you please say that you will? Thank you. Would you please sign? Thank you. So, for the record, for purposes of these proceedings, the court will order that Ms. Marcone will be the official transcriber of these proceedings without any further prior trial court approval. Mr. Haynes and Mr. Myers, you file a motion to appoint lead counsel, co-counsel. You want to be heard on that before we get into the arraignment?
Yes, sir. I think we just submitted it along with an entry. Ms. Barron had signed that on behalf of the state. You know, we're both certified. I'm certified as co-counsel. Mr. Myers is certified as lead counsel. We've already talked with Mr. Doerman. He is indigent, eligible for public defender representation. If we ask the court to appoint us, it would be appropriate.
All right.
All right. So that right there tells us, I don't know how well you guys could listen, and the subtitles, the captions are a little behind. But what he's basically, what they just established was that they requested that he have a public defender appointed to him by the court. So he's entering a plea of not guilty, but he needs representation.
Thank you, Jeff.
Here, so ordered. I've signed that entry.
So that's just to answer any questions moving forward, whether or not does he have a public defender or did he hire his own lawyer? So obviously he's not financially well off enough to afford an attorney. So he is requesting a public defender. So it will be a public defender representing him, which does not look good for him so far. And this community wants blood.
Start with the clerk, and she knows this, to send a notice to the Supreme Court of this indictment, but I want to put that on the record. Also, Mr. Haynes and Mr. Myers, there's a form from the Supreme Court. It's called an appointment form of trial counsel. I think the PD or the public defender prepares that. Do you know what I'm speaking
Yes,
of?
Your Honor, Mr. Haynes and I will take care of that after we're done on record today.
That's good.
We'll bring it to your staff, and I think it falls to the court then to forward that to the Ohio Supreme Court.
I think you're right.
And a very common question that I'm going to see pop up quite a bit is something along the lines of this one. In some form or another, I'm going to see this a lot. Why plead not guilty when he has already confessed? They're saying that it's a standard plea, and I'm assuming my common sense tells me that it causes me to assume that the reason why he's pleading not guilty, even if he's confessed, is because they are seeking the death penalty. Whether he pleads guilty or not guilty, they're seeking the death penalty. And basically, pleading not guilty would be a standard plea for the simple reason that it's his only chance of surviving. It's his only chance of living through this. Calamity Jade, thank you so much. Sugar Priss, Eagles local and willing to cover in person. Okay, I mean, if you choose to do that, right on. Good for you. If you're local and you want to cover it in person, you're not going to do that on my behalf. I don't want people on for my sake to be taking cell phones into the courtroom if they don't want cell phones in the courtroom, much less taking them to the celebration of life that's supposed to take place for these three boys. I think that that's sacred. I think that's for the community, and I think that should be left alone, and that should be for the community alone, and allow them to mourn in whatever way that they see is the most respectful way to their memory and to their mother and sister. So if I mean, this is YouTube, man. If you're local and you want to cover it, launch your channel. And I wish you the best of luck, but I'm good on my end. Thank you.
And then the court will send its own entry to the Supreme Court verifying that the clerk has sent a copy of the indictment to the Supreme Court. So I'll leave that record. All right. Does Mr. Doerman have a copy of the indictment?
Yes, Your Honor.
You've already provided that with for
Yes,
him?
we went over it with him as fate would have it in jail last night. Due to certain security restrictions he's facing at this stage, he didn't physically have a copy, but we gave him one. We understand that jail staff also alerted him to the existence of the indictment shortly after it was filed.
All right, as to Mr. Doerman, Mr. Haynes, and Mr. Myers, is he eligible then for
as the prosecutor said, they got his confession. Can this be used in the trial as evidence? It absolutely can be used in the trial as evidence. Depending on the only way that I would imagine that gets thrown out and they can't use it is if they got the confession a certain way that was unscrupulous or a violation of his rights in some way, shape, or form. So I don't think. I think that if they have a confession, that's going to be the strongest piece of evidence that they have in order to convict him. But it just depends on the circumstances in which they obtained the confession.
public defender?
He is, Your Honor.
All right. The court will sign that entry. Now, relative to arraignment, my preference is in thanking Ms. Doerman for submitting to the court the possible penalties. I went over.
All right. So Amy M is saying, but there are witnesses to him doing it. That's also evidence. That's just more evidence, along with the confession. Like like a confession doesn't cancel out witnesses, and a witness's testimony is not going to cancel out the confession. You know, all one is going to do is back the other up. All one is going to do is strengthen the other. So what usually happens in these cases, if we follow enough trials, if we follow trials enough, and we pay attention to the process and we pay attention to what a prosecutor generally ends up doing, is the prosecutor, you'll see a whole lot of overkill, for lack of a better term. I apologize for that, but you'll see a whole lot of overkill in the sense that what they'll do is they'll have a witness testify to a certain incident that took place, and then another witness's account of the same exact scenario. So you're just going to hear a lot of repetition in a trial, but all that's doing is strengthening their case. All that's doing is strengthening the validity of their case. So it's making it airtight, as it were, the way they like to say. So if you have multiple witnesses and testimony from credible witnesses on top of a confession, then you got yourself what's known as a slam dunk usually. So we'll see. We'll see what happens. I'll be curious to know what kind of attempt he's going to make in his defense. But the only thing, I mean, the insanity plea, it hasn't happened yet. So we haven't gotten an insanity plea, but that's the only thing that I can imagine is temporary insanity, because if the reason why we can't find any evidence of any turmoil taking place prior to this incident, well, then that could help his temporary insanity case. I mean, one day he's father of the year, and then the next day he's executing his 3 small sons in front of their mother, in front of their half sister.
I think we also hopefully the the defense got a copy of it?
We did.
All right, so what I'd like to do, in my preference, would be, Ms. Barron Allen, like the last couple of cases we've had, I'd love for you to go through each count independently. Put on the record what the state believes the possible penalties are. Then I'm going to turn to Mr. Myers and Mr. Haynes to see if they agree. And then I'm going to ask Mr. Doerman if he understands. And then we'll move to count 2, count 3, count 4, count 5, all the way through. Are you okay to do that?
Your Honor, may I address the court from the council table?
Yeah.
Thank you, Your Honor. And yes, I could absolutely do that for the court. I wasn't sure since counts 1 through 3 are all charged under 290301A. If you'd like.
Excellent point, Gerda K. Excellent point. But again, remember that the not guilty plea is standard. It's the only way that this guy has even a chance to save his own life. Because even if he pleads guilty, the prosecution is seeking the death penalty, and they're going to recommend to the judge that he sentence him to death. This is definitely, if there is ever a capital crime in a capital punishment state, this is it.
Like to address them in group?
Individually, yeah, thank you.
Count 1, aggravated murder pursuant to Ohio Revised Code 290301A. There are multiple aggravating circumstances specifications attached to the underlying charge, including victim under 13 specification, force of conduct specification, felony murder specification, and firearm specification. The possible penalty, if convicted on the underlying charge of aggravated murder as well.
All right, Sugar Crisp, you know we love you here, and you know that we appreciate all your contributions to the chat. But even though I have no reason to think that you're being untruthful, what you're doing is adding hearsay in my chat. What you're doing is you're trying to establish a sense of credibility with yourself here, and saying that you know people that know him, and that is exactly what we don't do here. So unless there is someone who can contact me directly, and prove their association with this person, and they want to come up here and talk about it, because trust me, I will vet them before I let them up here. But unless they do, please try and refrain from stating these things that you're hearing through people in your community, because it's just not what we do here. Just because someone lives there doesn't necessarily mean that they're telling the truth. This is what we've learned from the Summer Wells case, folks. So please try to, and I understand the want, I understand that if you have this information that you're hearing through people because you live close to the incident, I understand that. I get that. And you want to just be able to clear things up, but you can't prove them. So since you can't prove them, you're going to have to just kind of keep it to yourself in my chat. I would really appreciate it if you did that. The rules aren't any different, just because the case is different.
Well as any of the aggravating circumstance specifications, his recommendation of death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior to and consecutive to any imposed prison sentence. There's also a possible fine of $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. And again, the firearm specification would carry that 3 years mandatory, which must be served prior and consecutive to any post-prison sentence. Again, same fine.
All right. Does the defense agree with the recitation relative to count 1, Mr. Myers and Mr. Haynes?
We do, Judge.
And Mr. Doerman, do you understand that?
Yes, sir.
All right, ask the count two, please.
Thank you, Your Honor. Count two is also charged pursuant to Ohio Revised Code Section 290301A, aggravated murder and unspecified felony. Again, there are multiple aggravating circumstances specifications attached to that charge. The victim under 13 specification, course of conduct specification, felony murder specification, and firearm specification. The possible penalties if convicted of the underlying crime of aggravated murder, as well as any of the aggravating circumstance specifications, would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification, again, is 3 years mandatory, which must be served prior to and consecutive to any imposed prison sentence, and a possible fine of $25,000. If convicted of the underlying aggravated murder charge without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, and life with the possibility of parole after 20 years.
I mean, there's 21 counts here, folks. So what we're looking at right now, and what we're listening to is this person who works for the prosecutor's office is pointing out what the law says these charges can come with as far as sentencing goes. These are each charge she's going over how much jail time comes with it, how much money and fines come with it. And so far we're seeing a lot of life sentences without the possibility of parole, or with the possibility of parole. But remember, there's 21 of these. The ones that are murder, those are capital murder charges. All they have to do is prove one count. All they have to do is get a guilty verdict on one count of murder for the judge to be able to hand out the death penalty. So this is, I just don't see a universe where this guy gets out of this. The only thing that makes me wonder whether or not this guy will ever get out of this is the fact that there's no history of anything that we're aware of prior to this incident. We don't have any violent history except for him choking his dad when he was 18 years old. We don't know what kind of anger issues he had. We don't know what kind of circumstances happened there. We could have been his dad fucking was beating the shit out of him, and then he choked his dad in self-defense. But regardless, the charges were dropped. For whatever reason, that charge was dropped. So it really doesn't matter. It kind of matters because we know he's capable of something, but we already know what he's capable of, don't we? We know what he's capable of because he's sitting there in orange scrubs in a courtroom with 21 different counts, 21 different charges, and 9 of those counts are aggravated murder. So we know what he's capable of. It's just, I mean, B, I've heard that rumor too. Again, that's just a rumor. We don't know. Maybe he did drink a lot. Maybe everything that Sugar Crisp is saying in the chat is all true. The problem is that it's just not verifiable right now. I can't verify it, so I'm not going to entertain it as fact in the slightest bit right now.
Years, and firearm specification is that 3 years mandatory, as well as a $25,000 fine.
Thank you. Mr. Myers and Mr. Haynes.
We agree, Judge.
Okay. And Mr. Doerman, you understand? As the count 3, Ms. Farron.
Thank you, Your Honor. Count 3 is also charged pursuant to Ohio Revised Code Section 290301A, aggravated murder, unspecified felony. It also carries with it multiple aggravating circumstance specifications, the victim under 13 specification, course of conduct specification, and felony murder specification, as well as that firearm specification. The possible penalties if convicted of the aggravated murder, as well as any of the aggravating circumstance specifications, would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. Again, the firearm specification carries with it that 3 years mandatory, must be served prior to and consecutive to any imposed prison.
So just look at this guy right now. He's just staring off into space as though like he just knows his life is fucking over. Like this guy's life is destroyed regardless. Think about that for a second. Let's say that he gets off on a technicality. Let's say that he's found not guilty. Let's say he's found not guilty and it turns out that he's actually genuinely sorry about what happened, and for some whatever medical reason, let's just say for whatever medical reason, he somehow had no control over what he did, had no say over what over his actions. If that's the case, his life is ruined, because he's either going to die at the hands of the justice system for what he's done, or he's going to have to live with the fact that he murdered his 3 sons. I mean, this guy's life is over. Because I mean, this guy can't go on with his life. We look at Casey Anthony and we're like, you're a piece of shit. Like, there's no way. Like, Casey Anthony loves being social. That's something that we've learned over the years, right? Casey Anthony loves to be social. She likes to go to bars. She likes to wear her little fedora fucking and be all stylish at the bar, you know, and get wasted and still fucking act like the same way she was fucking doing when Kaylee was missing. She loves she loves the attention from being social. You know what I mean? But that's because we know that she's a cold-blooded cunt. We know this. There's no doubt in any of our minds that this was a party girl who loved to party, and she fucking put duct tape on her kid's mouth and tied her up, and Kaylee probably suffocated because she wanted to go out and party and she didn't have a sitter, because she didn't want to face the responsibilities of being a young mother. That's totally what I think. I don't give a fuck what anybody else says. That's totally what I think. All the evidence says so. The only thing Jose Baez did was create doubt in a jury. That's all he did. That's his job. Jose Baez's job as a defense attorney is to create doubt in a juror's mind. One juror. That's what he pulled off. The jury fucking knew. The jury knew she was guilty, but they were like, oh, man. Somebody in that jury was like, I don't know. But I guarantee you nobody in that jury was just like, no, she didn't do this. I guarantee you nobody in that jury was doing that. I guarantee you it came down to, we can't convict if there's even the slightest shred of doubt. And the defense did a good job of creating doubt here, because here we are, and none of us can come to a full-on lockdown agreement. That's all it takes. But I firmly believe that Casey Anthony is completely guilty and totally cold-blooded and doesn't give a fuck about anybody but herself. I firmly believe that. But this is different. This is different. Because this guy, I mean, there's just way too much evidence that there seems to be against him. There's nothing, there's so far we're not seeing evidence that he liked to ditch his kids and he didn't want nothing to do with them, and And we got one guy who's just not credible saying that he witnessed child abuse, but he didn't fucking report it. Oh, I seen him tossing around in the front yard there. Dude, shut the fuck up. So the thing is again, this is not like a Casey Anthony type situation where we see a pattern of behavior that strengthens a theory of motive that she just didn't want to be tied down by the responsibilities of a young mother. This is not what we're seeing here. We see evidence to the contrary of that, according to people that knew this man, according to his Facebook posts. This guy comes off as though his whole life was those three boys. So he's either going to get the death penalty, which I think will happen, but even if he gets off, this is a guy who everything tells us that if he wasn't responsible for his actions for whatever medical reason there was, whether it be psychological, whether it be, for all we know, the guy's got a fucking brain tumor. You know? For all we know, the guy's got a brain tumor. Who knows? But if that's the case, this is a guy who's going to live with this shit for the rest of his life. And I don't think that he doesn't strike me as the type that can. Mr. Harlan, yeah, man. I hear you, dude. Evil must be executed. To quote the great Quentin Tarantino, you only need to hang mean bastards, but mean bastards, you need to hang.
Prison sentence and the $25,000 fine is possible if convicted of aggravated murder without any aggravating circumstance specification. The possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and again, the firearm specification is 3 years mandatory and same time.
Thank you. As to count 3, does the defense agree with the possible penalties that have been recited?
Yes, Your Honor, we do.
For the record, Mr. Haynes, Mr. Doerman, you understand? Yes, Your Honor. Thank you, Mr. Baron Allen. As to count 4, please.
Thank you, Your Honor. Count 4 is charged pursuant to Ohio Revised Code Section 290301B, again, aggravated murder and unspecified felony. There are multiple aggravating circumstance specifications attached to that count as well. Same aggravating circumstance specifications for victim under 13, course of conduct specification, and felony murder specification, as well as that firearm specification. Again, convicted of aggravated murder, as well as any of the aggravating circumstance specifications, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, or life with the possibility of parole after 25 years. The firearm specification again carries that 3 years mandatory, which must be served prior and consecutive to any imposed prison sentence, and the possible fine of $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and that same firearm specification of 3 years mandatory, and the same fine of $25,000.
Thank you. Mr. Myers or Mr. Haynes? We agree, Your Honor. You agree. Mr. Doerman, you understand? Thank you. As to count 5, Ms. Baron.
Thank you, Your Honor. Again, count 5 is charged pursuant to Ohio Revised Code Section 290301B, aggravated murder and unspecified felony. Also attached are multiple aggravating circumstance specifications, the victim under 13 specification, course of conduct specification, felony murder specification, and firearm specification. If convicted of the underlying crime of aggravated murder, as well as any of the aggravating circumstance specification, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification is 3 years mandatory and possible prison sentence. It must be served prior to and consecutive to any imposed prison sentence. The possible fine of $25,000. If convicted of the aggravated murder charge without any of the aggravating circumstances specifications, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, with a firearm specification again at 3 years mandatory, and the same fine of $25,000.
Thank you, Mr. Myers and Mr. Haney. We agree with that. Mr. Doerman, you understand? Thank you, Ms. Allen. As to count 6, please.
Thank you, Your Honor. Again, count 6 is charged pursuant to Ohio Revised Code, section 290301B, aggravated murder and unspecified felony. Attached to that count, multiple aggravating circumstance specifications, the victim under 13 specification, course of conduct specification, felony murder specification, as well as the firearm specification. If convicted of the underlying charge of aggravated murder, as well as any of the aggravating circumstance specifications, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, or life with the possibility of parole after 25 years. The firearm specification carries that 3 years mandatory, which must be served prior and consecutive to any imposed prison sentence. A fine of $25,000 is also possible. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and that's firearm specification, 3 years mandatory, and that same possible fine of $25,000.
Thank you. Does Mr. Myers and Mr. Haynes, you agree with that?
Yes, Your Honor.
Mr. Doerman, do you understand? All right. Thank you, Ms. Allen. As to count 7, please.
Thank you, Your Honor. Count 7 is charged pursuant to Ohio Revised Code section 290301C, aggravated murder, unspecified felony. There are multiple aggravating circumstance specifications attached, including victim under 13 specification, the course of conduct specification, felony murder specification, and firearm specification. The possible penalties are possibility of death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior and consecutive to any imposed prison term.
Yeah, see, I was wondering about that too. I'm confused about that. That's something I'd have to speak to an attorney about. That's a question that I would definitely have for Jess Mystery Maven Esquire. But you know, she is an attorney, so she can't catch every live. But I'm always grateful when she's in my chat, because when we're talking about things like this, because you know, it's nice to have an attorney that I can reference to. But I'm really curious about that too. How can they have how can they charge them 3 times for each child's murder? How are there 9 counts of murder with 3 victims? That's I don't have answers to that. That's something that I would need to ask an attorney. I don't think that matters, headstones and headlines. But I thought of that too. There are 3 ways to murder someone. What do you mean there's 3 ways to murder someone? There's more than 3 ways to murder somebody. Okay, so okay, maybe that has to do with because they were children under 13. Because I see that a lot in the indictment. In the indictment, there's a lot of victim under 13 years of age. So maybe they get charged for, maybe there's a law in Ohio where you get charged because they're under a certain age. Well, the charge was dropped, Cinnamon Hot Hot Hot. The charge was dropped. So Yeah, but they're all aggravated murder charges. I don't know. Maybe I'm missing something. Maybe I'm misunderstanding something. You guys are way smarter than me. I don't...
And the possibility of a fine up to $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and same firearm specification in 3 years mandatory, and that same possible fine of $25,000.
We agree, Your Honor. Thank you, Mr. Haynes. Mr. Doerman, do you understand? Thank you, Ms. Mayor. I'm going to ask to count 8, please.
Thank you, Your Honor. As to count 8, again, that is charged pursuant to revised code, section 290301C, aggravated murder and unspecified felony. There are multiple aggravating circumstance specifications attached to that count as well. The victim under 13 specification, force of conduct specification, felony murder specification, and firearm specification. If convicted of the crime of aggravated murder along with any of that aggravating circumstance specification, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior consecutive to any imposed prison term, and a fine of up to $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. Again, the same firearm specification, 3 years mandatory, and the same possible fine of $25,000.
Thank you. Mr. Myers and Mr. Haynes. We agree with that. Mr. Doerman, you understand? I'm sorry. I understand. Thank you. As to count 9, Ms. Mayor.
Again, count 9 similarly is charged pursuant to Ohio Revised Code, section 290301C, aggravated murder and unclassified felony. Attached are multiple aggravating circumstance specifications, including the victim under 13 specification, of course of conduct specification, felony murder specification, and firearm specification. The possible penalty if convicted of both the aggravated murder and any of the aggravating circumstance specifications would be.
Calamity Jade, thank you. With Tesha, one was person in position of safety and care. Okay, that makes sense as well. Thank you. Well, I get all that on the case with Jeannie.
Death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior to and consecutive to any imposed prison sentence, and a possible fine of $25,000. If convicted of aggravated murder without any of the aggravating circumstances specifications, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. Again, firearm specification carries with it that 3 years mandatory and the possible fine of $25,000.
Thank you, Mr. Myers and Mr. Haynes. We agree with that. Mr. Thank you, Ms. Farrell. As to count 10, please.
Thank you, Your Honor. Count 10 is charged pursuant to Ohio Revised Code, section 290501A3, as kidnapping, a felony of the first degree. There is also a firearm specification attached.
All right, we just want to update viewers. If you're just now joining us, what you're watching right now is Chad Doerman's arraignment since a grand jury handed down charges yesterday, quite a few of them. He was initially charged with 3 counts of aggravated murder back about a week ago when those 3 boys were killed. Yesterday, the grand jury came to a conclusion, many conclusions about what he is facing right now. And what you're seeing going on in court is the judge, Judge Victor Haddad, has asked the court and the prosecutors to go through each and every charge one by one to make sure that Chad Doerman's attorneys and Chad Doerman himself.
Okay, I would assume you're a true crime channel on the case with Jeannie. Well, let's be careful here. If you're a true crime channel, then know that allegedly he admitted to planning it. According to the prosecutor, he admitted to planning it. There's nothing, we haven't seen any evidence of that ourselves just yet. It's a prosecutor's job to say these things, but in your defense, I don't think that a prosecutor would say these things unless he could prove it, especially if he said it in court. And then you're saying that there's a couple of people saying that he's mean to the boys. I only heard one person say that, and it's somebody who says he witnessed child abuse take place in the front yard and he didn't report it. So his credibility with me is non-existent. So again, we don't have enough information just yet.
Understand what he is being charged with. All 21 of these charges. He has 9 counts of aggravated murder, 8 counts of kidnapping, 4 counts of felonious assault that the grand jury came up with. So this is the arraignment. The first time he is hearing these charges in person. He's sitting there in the orange next to his attorneys. Does not have on the protective green vest that we saw him in last week, but he is hearing these charges for the first time. And we may get a plea deal at the end of all of this. So we'll send you back to the courtroom to continue to listen in. I think they have about 10 to 12 more charges to go through. We will hear what the judge decides to do next once the prosecution finishes reading off each and every charge against Doerman for the alleged killing of his 3 sons, 7-year-old Clayton, 4-year-old Hunter, and 3-year-old Chase. We'll take you back to the courtroom right now.
Specification would be 3 years mandatory to be served prior and consecutive to any other imposed prison sentence and a fine of $20,000.
Thank you, Mr. Haynes. Mr. Doerman, you understand? All right. Thank you. As to count 12, please.
Count 12, again, charged pursuant to Ohio Revised Code Section 29050183, kidnapping, a felony of the first degree, as well as a firearm specification. As to the charge of kidnapping, there is a presumption of prison and rank totes will apply at sentencing. The minimum term of prison that is possible is 3, 4, 5, 6, 7, 8, 9.
Bro, you don't know that. You don't have any evidence of that on the case with Jeannie. It concerns me that you're on any case at this point. It concerns me of the thought of you being on any case, because you're jumping to these conclusions and making these judgments and these psychological diagnoses. And yeah, we don't do that here, just so you know. Come with evidence. Don't just say these things.
9, 10, or 11 years, up to the minimum term imposed plus 1/2, again by way of example, 11 to 16.5 years. The firearm specification would be 3 years mandatory to be served prior and consecutive to any prison term imposed, and a possible fine of $20,000.
Thank you, Mr. Myers or Mr. Haynes. We agree. Mr. Doerman, do you understand? Thank you. As to count 13, please.
Count 13, also charged pursuant to Ohio Revised Code Section 29050183, kidnapping and felony of the first degree, as well as the firearm specification. There's a presumption for prison convicted of kidnapping, and rank totes would apply at sentencing. The minimum term possible would be 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, example, 11 years imposed, it would be 11 to 16.5 years. The firearm specification is 3 years mandatory. Again, must be served prior and consecutive to the prison sentence imposed, and a fine of $20,000.
Thank you. Mr. Haynes or Mr. Myers? We agree. Mr. Doerman, you understand?
Yes, sir.
Thank you. As to count 14, please.
Count 14 is charged pursuant to Ohio Revised Code Section 290501A2, and kidnapping, a felony of the first degree, as well as a firearm specification. There's a presumption for prison, and rank totes would apply at sentencing. The minimum term possible is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, 11 to 16.5 years. The firearm specification is 3 years mandatory, and a $20,000.
Orion Artist, thanks for listening while you work. I hope that it's making your workday go by easier. You're saying, do we know what happened to Mom? Is she okay? Did he harm her? Is she in the picture? She is in the picture. Mom is also a victim. Mom was shot in the hand, presumably from trying to protect one of her children. So she suffered a gunshot wound in the hand. That's all we know so far. Bro. Oh my God. So yeah, Orion Artist, I hope that answers your question. That's all we know so far, but she's absolutely a victim in this case. This happened because they live in a rural area and neighbors aren't close. Is that why it happened? Really, bro? Is that why it happened? Bro, you get one of these. This is your comment gets bro, seriously, like like think before you type. All right, court adjourned.
Thank you, Mr. Myers. We agree. Mr. Doerman, you understand? Yes, sir. Thank you. Is it count 15, please?
Count 15 is again charged pursuant to Ohio Revised Code Section 290501A2, kidnapping and felony of the first degree, as well as the firearm specification. The kidnapping, there's a presumption of prison, and rape and toast would apply at sentencing. The minimum term possible would be 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 11 years is imposed, it would be 11 to 16.5 years. The firearm specification is 3 years mandatory and is $20,000 fine.
We agree. Thank you. Mr. Doerman, you understand? Yes, sir. Thank you. As to count 16, please.
16 is also charged pursuant to Ohio Revised Code Section 290501A2, kidnapping and felony of the first degree, as well as Ohio.
Thank you.
Oh, look at this cop here, bro. He's all business. You know that dude never fucking pulls somebody over without giving him a ticket. You're getting a ticket from this guy no matter what. I don't give a fuck who you are. I don't even give a fuck if you were doing the speed limit. This dude is writing you a ticket, guaranteed. Look at him.
As to count
all
16, please.
16 is also charged pursuant to Ohio Revised Code Section 290501A2, kidnapping and felony of the first degree, as well as the firearm specification. Again, there is a presumption for prison, and rape and toast would apply at sentencing. The minimum term is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2, which would, for example, would be if 11 years is imposed, it would be 11 to 16.5 years. The firearm specification is 3 years mandatory and a $20,000.
Thank you, Mr. Haynes.
We agree, Your Honor.
Thank you, Mr. Doerman, you understand?
Yes, sir.
As to count 17, please.
Count 17 is also charged pursuant to Ohio Revised Code Section 290501A2, kidnapping and felony of the first degree with a firearm specification. Again, there is a presumption for prison, and rape and toast will apply at sentencing. The minimum term is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 11 years would be imposed, the prison sentence would be 11 to 16.5 years. The firearm specification is 3 years mandatory, and the possible fine is $20,000.
Thank you, Mr. Haynes.
We agree, Judge.
Mr. Doerman, you understand?
Yes, sir.
Thank you, Ms. Aaron Allen. As to count 18.
Thank you, Your Honor. Count 18 is charged pursuant to Ohio Revised Code Section 290311A2. It is felonious assault, a felony of the second degree, and there is a firearm specification attached to that. Again, there's a presumption for prison if convicted, and rape and toast will apply at sentencing. The minimum term possible will be 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 8 years would be imposed, the sentence would be 8 to 12 years. The firearm specification is that 3 years mandatory, which must be served prior and consecutive to any other person sentence imposed, and the possible fine is $15,000.
Thank you, Mr. Haynes.
We agree, Judge.
All right, Mr. Doerman, you understand?
Laugh at Life, member for 5 months. Welcome to Logic. Thank you.
Thank you. As to count 19, please.
Count 19 is charged pursuant to Ohio Revised Code Section 290311A1. That is also felonious assault, felony of the second degree with a firearm specification. Again, there is a presumption for prison, and rape and toast applies. The minimum term would be 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 8 years was imposed, the prison term would be 8 to 12 years. The firearm specification is at 3 years mandatory, and the fine is $15,000.
Thank you, Mr. Haynes.
We agree.
Mr. Doerman, you
All right, if you're just tuning into WLWT, this is the arraignment of Chad Doerman after he allegedly killed his 3 sons a little more than a week ago. What's happening right now is the prosecution is going through each and every charge against him that a grand jury handed down yesterday. 21 additional charges on top of the 3 charges he was given from last week. And the Judge Victor Haddad, has asked the prosecution to go through each and every charge, which is 9 counts of aggravated murder, 8 counts of kidnapping, and 4 counts of felonious assault, to make sure that Chad Doerman himself and his defense team all understand what he's facing. Some of these carry some long sentences, but some of these charges do carry a possible death penalty sentence. So they're going to wrap them up in the next couple of minutes. I think they just went through count 20 right now, and then we will see where the judge decides to head from there. Since this is an arraignment, there's a chance that we could hear a plea from Chad Doerman towards the end. But let's take you back out to the courtroom in Claremont County to hear the last few charges before the judge continues on with this arraignment.
By sentencing, the minimum term would be 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. And by way of example, if 8 years was imposed, the prison term would be 8 to 12 years. The firearm specification is that 3 years mandatory, and the fine possible up to $15,000.
Thank you, Mr. Haynes.
On the case of Jeannie, calm down, relax. You're over here yelling and screaming. You got to relax, calm down. Like, I get it. These people, these child killers, we don't like them here. I understand that, but we got to wait for facts, evidence, testimony. But I get it. You know?
We got a special disliking for these bunkolas.
Exactly. See what I mean? We're with you. Don't worry. Calm down.
Mr. Doerman, you understand? All right, I think that covers the entirety of the indictment.
It does, Your Honor.
All right. At this time, Mr. Myers and Mr. Haynes, based upon the recitation of the indictment and all the possible charges and possible sentences, what is the plea of your client at this time?
Plea is not guilty, Your Honor.
All right.
We reserve the right to file later pleas.
Absolutely.
Thank you.
Because of the
Okay,
nature.
see, that's very important right there. He said we reserve the right to file later pleas. He pleads not guilty. So right there is when he officially stated to the court that his client pleads not guilty and that they reserve the right to change their plea later or add additional pleas later.
Judge, I should say, I think Mr. Myers touched on it, but it hasn't been quite 24 hours since he was indicted or read the indictment, so he's going to waive the 24-hour waiting period.
Okay, thank you. Would you please, Mr. Haynes, step up, and then if you and Mr. Myers could sign as attorneys for Mr. Doerman, and then have Mr. Doerman sign.
Hey, Cherry, we're gonna need you to keep up with the rest of us, okay? Like we're way up here and you're lagging behind. We need you to catch up with the rest of us, okay, Cherry? Thank you. Oh man, I'm in trouble.
We decided, Judge.
Thank you. So for the record, Mr. Haynes, you signed, Mr. Myers, you signed, correct?
Correct.
All right. And Mr. Doerman, you signed as well. All right. As to bond statement,
I'll be discussing bond. Your Honor, as the court is aware, pursuant to Article 1, Section 9 of the Ohio Constitution, this
Judge, we're not going to object to bond.
We pass on.
meaning that if he's asking for, they're going to ask for a no bond.
Correct.
And
We're not opposing that.
are you comfortable with that, Mr. Coleman?
The Constitution says where proof is evident and
Continue. Go on, continue.
Judge, I think.
Take a record.
Thank you, Your Honor.
Yeah, there he was again, man. Check him out.
The Constitution says where proof is evident and
Man, hurry up with that license, meow. You heard me, meow. I said, I need your registration. Write me out. Write me out.
Continue. Go on, continue.
Judge, I think
Make a record.
thank you, Your Honor. The court needs to have some understanding of the facts. What we have here is the planned slaughter of 3 little boys, ages 7, 4, and 3. The first one shot was a 4-year-old, shot in the house 2 times, then sustained 2 bullet wounds to the head, causing his death. The second child shot was a 7-year-old who fled the residence, ran some 300 feet from the residence, and was gunned down from behind by the defendant. We then approached this little boy who was injured, incapacitated, alive, shot him in the head twice from close distance. There were powder burns on the boy's head. And then he went after the 3-year-old. And there was a struggle with the mother. He ripped the child from the mother's arms, put a bullet in his head. Close range, powder burns on the 3-year-old boy's head.
Oh my God.
Your Honor, those facts are important for the court to know in terms of this being a capital case. We find, Your Honor, my conclusion is that proof is evident and the presumption is great that he be held without bail.
All right. Thank you. Defense has nothing to add.
No, Your Honor.
All right, the court's going to order based upon Article 1 of the Ohio Constitution, Section 9. It's been amended on November 8th of 2022. The bond in this case be no bail at the present time. And what the court's going to do is prepare an entry that contemplates that, because my normal judgment entries do not contemplate Article 1, Section 9. So we'll put one together indicating the court's order of no bail. Anything from the defense at this time? Anything else before the court notes that the case is assigned to Judge Ferentz? And the court date, we want to work around schedules. Do we have a date?
Originally, it was set for July 5th. Is there another date?
Is that a bad date?
It's up to the attorney.
Can everyone do July 5th?
I can do that, Judge.
Yes, Judge.
Yes, sir.
Okay, Mr. Myers?
The 5th would work. I might indicate, as I'm now reminded by co-counsel Mr. Haynes, we're before this court the following day on Mr. Guilfoyle's case, and I would wonder if,
At 10:30.
I mean, obviously I'll work with both court schedules.
Well, we want to work with your schedule, but I think the heightened security is a little too much for us to have both of them
Oh, I see.
at the same time, because they're both death penalty cases.
So
But I know you've come a long way, but.
that's all right. Part of the job.
All right.
So we'll be down here on the 5th for a pre-trial
Yes,
then? Okay.
and we're looking at the time, because I'm trying not to insert it on his regular docket so that Judge Ferentz has some time.
Gotcha.
It could be 10 o'clock, 11 o'clock, or 1 o'clock.
All right. I guess they're just settling on. Okay. So I'm glad you said this, Loriello. Loriello says, I don't get it. When a criminal confesses right away, who cares what happened to them? He confessed already, damn it. Because you don't know what circumstances they confessed under. You don't know what the circumstances were. You don't know if their rights were violated. You don't know if they were still under some sort of mental duress. There's all kinds of different things as to why. I mean, things are not just black and white. We need to get in the habit of learning this. We need to get in the habit of learning this, people. When we follow these cases, this is not a TV show. The law is very, very complicated. It's not, I mean, you got to think, like when you watch a court proceeding in a movie or a TV show, it's dumbed down for those of us who don't understand the law fully. So there's all these other gray areas. There's all these things, these technicalities that the defense can possibly use. We have no idea what that interrogation happened. What happened in that interrogation? I mean, it's fair to even possibly doubt, because even in the footage, like, dude, the footage where they were taking him away and he was talking about something about his cuffs. I can't remember what it was he was saying, but they were like, shut up. The cops were like, shut up. You got the right to remain silent. Use it. Like, these cops were disgusted with this guy. These cops were emotionally affected. They were emotionally affected by this incident. So who knows what happened? I just hope that his rights weren't violated so they can get a clean conviction.
About 11. Is that all right with everybody?
Does that work for everyone? Okay, 11 o'clock. For the court's own edification, Mr. Doerman, can you please tell me how old you are?
32.
And what's your date of birth?
3191.
And are you a citizen of the United States?
Yes.
All right. At this point then, Mr. Haynes or Mr. Myers, is there anything else that you want the court to consider?
That's a good question, Calamity Jade. Why not aggravated assault on shooting the wife? They're stacking charges, it seems. Agreed. They do seem to be stacking on any charge they could possibly tack on to him. For sure. The only thing that I can think of in theory, the only thing I could speculate on, again, I'm not an attorney. I have no idea. But I'm wondering, possibly, the only thing that makes sense to me would be they have so much already. Why put the wife through anything further? Does that put her in a position to where the defense is going to make her testify? I mean, I don't think the defense would ever call on her to testify, but I'm saying, would that help their case overall? I mean, what comes with having that charge? You know what I mean? Do they want to, there are assault charges, yes. But if they don't charge him for assaulting the mom, I really hope they don't call her onto the stand. I hope that this poor woman does not have to relive this horrible ordeal. And God forbid that they make the teenage stepdaughter, God forbid they make the teenage stepdaughter testify in open court. I really hope that doesn't happen. I really hope that doesn't happen. But I'm thinking if they didn't charge him with shooting the mom in the hand, they probably just don't see any real benefit from it. Probably more. I mean, the idea is to get her justice. The idea is to get the half sister justice. So that's just my theory. I don't know. I mean, it's based on nothing, you know.
I think just on the technical front, we would waive the reading of the indictment. We discussed that with Mr. Doerman at length yesterday.
Thank you. Would the defense have any issue? I'm just asking, waiving time till the next hearing?
No, Your
Yeah. All right. Terry, can you tell me that date again, please?
July 5th at 11 a.m.
And we're going to call it a retrial. And then, Mr. Myers and Mr. Haynes, would you please sign as attorneys for the defendant, have Mr. Doerman sign, and then have one or all three of the prosecutors sign? Bless you. She looks at both. She might be sentenced. Okay. Oh, thank you. Thank you, Mr. Haynes. For the record, Mr. Haynes, you signed the time waiver.
We did, Mr. Doerman did, Mr. Myers did, Judge, yes.
And Mr. Doerman, you signed it. Yes, Mr. Prosecutor.
I did, Judge.
Right before it signed it. Also, the court received, for the record, the appointment of trial counsel on the capital case. Here it is. Mr. Haynes and Mr. Myers, I need both of you, one to decide as lead and one as co-counsel, if you would, so we can get that to the Supreme Court. Let me make sure. 0407.
Your Honor, approach.
Yeah, I don't know that I'm gonna be the trial judge on this. It's gonna be Judge Ferris. I think you need to put Judge Ferris on there.
It came from Greg Myers.
No, Rick, I was doing that as we were doing all the penalties. And I wasn't sure if it should be the appointing judge, or I think you're probably right, it should be the assigned judge.
I would think,
So,
or both, but I think you need to be on there because, the only issue is because your signatures, I don't know if these are signatures or if we can just put your name. I think we have to sign. We do have to sign. So can you redo that?
I can.
Just change, I don't know Judge Ferris's registration number.
Yeah, I can find all that when we're on the record, Judge. It takes a little bit to do it.
No, that's fine. I'm gonna put that to the side, so we'll be on you to try to get that. Let's see if I have anything else on my list. Anything else, defense? Anything the state can think of? Any questions, Mr. Doerman?
There.
All right, court's in recess for this purpose.
Thank you, Your Honor.
All right.
All right, so that's it. So I've got the call-in number on the screen there. So if anybody wants to call in and air their grievances, anybody wants to call in and express their opinions on this matter so far, you're welcome to. You're on. Who am I speaking with?
It's Crispy Treat / Sugar Crisp.
What's up, Crispy Treat?
well, there's a lot that's been up, you know. I really was trying so hard. I really did think that I had confirmed what I could confirm, just those little bits of things that I had. But I thought, as soon as I put it in chat, I was like, I know I'm going to get it. I know I'm going to get it.
So what'd you put it in there for?
because I thought that I did check it out, though. See, like, if this couldn't be a better situation as far as me just trying to, I'm not just putting in gossip. I checked this out. See,
Okay, but I have no way of checking it out. These people have no way. We can't just take your word. We can't just take your word for this stuff. You know how this works.
Well, yeah, I guess so.
Yeah.
But
just because you know it to be reliable doesn't mean the rest of us do.
Well, I had a channel for a long time. I had a channel for years. It was a big channel. It was nice, and it was Partners in Crime. But then my partner left, and then I didn't have much. I just didn't. I don't know. I always thought that I would keep creating stuff, but without a partner, I didn't really have a channel that was Partners in Crime and just me. But anyway, I mean, I don't know how else to verify, but I'm telling you, my ex is a newscaster there on Channel 5, and my bestie is we were all three roommates for like 10 years. They're on 5 and 12, but everybody hangs out together on all those news channels or whatever. So not only did I know the people that worked with the guy, I mean, I didn't know the one guy that well, but I knew the other two real well. Like I went to grade school with one and high school with the other. But I mean, I didn't go to high school with them, but I went around the same time. And they're like good people, like normal people and stuff. And so that I couldn't really check out with my news friends, but my news friends did tell me some things, you know, they were just little things. I wasn't putting in a bunch of, because I could have put in a ton of stuff, and you know I could have.
Okay, let me ask you this.
Yes.
Okay. Why haven't your news friends put that stuff on the news?
Well, because I guess there's really not a place for it on the news, you know, like there's not a conversation.
What do you mean? The motive, the why? That's not a place on the news? Of course it is.
Yeah, that's it. I wasn't.
No, it's a rhetorical question. You know why they haven't put it on the news?
Because it's not.
Because it's rumor.
Right. Yeah. Mm-hmm. It is.
Right. That's why they don't put it on the news. That's why I don't put it on here.
Right.
Okay.
But I really tried to do the best I could to I mean, I got that stuff on them. They're the ones that told me that. They're the biggest gossips ever, by the way.
But you're the one saying it here.
Oh, I'm sorry. I was really trying so hard, and I thought you'd be so happy. And
No. Zav girl would be. I no. You come on. You were here. You're very active in my chat. You have been for quite a while now. You know how this works here.
I know. I do too.
Yeah, that's all.
I do. I couldn't believe it. But I just thought, like, since they told me, I felt like, my God, I mean, I didn't just get this from, like, friends from high school. I got this from, like, the actual news people. I mean, how many people have that going on? You know, that was pretty good. That's pretty good verification in my head, at least in my own little head. I thought that, like, that was going to be impressive. But it sounded good last night. I would have called you, but I was like, I couldn't get a hold of, I didn't know how to get a hold of anybody. And I was like, because I wanted to, like, ask you all this stuff before I said anything. But then, oh, well. I mean, but I knew you would. I felt like it was a good teaching moment for anybody that hadn't been here long. That you.
No,
you were,
no, it's
yeah,
counterproductive to what I
tell
do
me.
here. It's totally
You're gonna
counterproductive to what I do here.
No, it's not, because people
It
don't
is.
know.
It
and
is.
then you'll come off real mean, and people will think that you like. Because I hear that all the time. I'm like, you guys just give him a chance. Like, he's not really warm and fuzzy, but he's got a really big heart. You just can't get offended by him, because you do come off really harsh sometimes, and people get their feelings hurt. Because you like, and you don't mean to. Like, you just will say things like, you're just so blunt, you know. But I mean, we all love you for that, but it's, you know, sometimes like a new person gets like scared a little bit. Like, I hear that stuff, you know, people are like, oh, you know, there'll be like a million people saying, oh, I love the glare. And then there'll always be somebody that's like, I just was in there and he fussed at me or something, you know? And it's like, I understand what they mean.
No, all I did was just point out that what you're doing can't be verified, at least not yet. So it doesn't help to put it in the chat. It's just rumor. If it can't be verified, it's rumor.
I said it was my opinion, you know, too. I did put that in there. Doesn't that help?
I mean, not if you're stating it as fact and saying, I know this person and I know that person and this is what they told me.
Well, and
that's not an opinion. That's hearsay.
Yeah, you're right. It's true, though. I mean, you're right.
I know.
You're right. I know better. I know better. I do. I really do.
I know you know.
But see, yeah, I've been around a long time, but I felt like I could be like the example of what not to do too, you know.
Oh, you achieved that. Congrats on that.
If you take it out on me, then people will know better than, like, what did that new person just say? Like, that was like, what did you say? What did you just say to that last person? You said, I'm really concerned about you working on any case.
Well, yeah, because she's on the case, but she's just like, I mean, she straight up like said in my chat, she typed it out in all caps, talking about that the reason why it happened because it was in a rural area. What?
Yeah, and it's not in a rural area either.
It's not, right?
It's like, yeah, it's not. I mean, the houses are pretty close together.
Yeah.
You know, it's
that was just somebody saying something just abundantly stupid, and I don't have patience for that. You know, I don't.
You don't, but you have to, though. You have to be nice. Like, you can't.
Do I though?
People like that.
No,
people aren't trying to
I disagree.
They're not trying to piss you off.
I disagree.
You just have to try and like be a little bit sweeter about that, because it's hard trying to defend you all the time, you know, when people, I'm like, oh, he didn't mean that. Like, go back in there. You'll like them better. And people always do say that too. They always do tell me that. They always say, I gave him another chance and I liked him better the next time. But sometimes we can catch you on a bad day. It's like, it's scary. You know,
I don't know, man. Next time you talk to him, tell him to write a letter or something. I don't know what to tell him.
But okay, well, and then what should I do if I find out anything else? Should I text you? Can I have your personal phone number?
No.
Please?
No.
And I won't bother you much.
Okay, I'm going to take the next caller. Thanks for calling, Crispy Treat. I appreciate it. Bye-bye. Okay, the line is now open for the next caller. I'll be HR. Oh my God. Yeah, I agree, Grandmaster Sid. I am very, very proud of my chat. I love my chat very much. And including Crispy Treat. She's part of my chat. She's always been very supportive. Hell yeah, you see Neil Diamond on my shirt. I love Neil Diamond. Nobody else wants to call? Nobody? 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 Oh, Jones and behave. Stop it. All right. Well, I guess I'm going to wrap this up then. So, I mean, we're all caught up, people. July 5th would be the next hearing. I believe they agreed on 11 a.m. What time zone is Claremont in? Is it Eastern time? Is it Central time? It's either Eastern or Central. I'm gonna guess Central time, maybe. But yeah, I'm gonna guess Central time, but whatever. We'll figure it out. We'll cross that bridge when we get there. But yeah, so he's got a not guilty plea. They are seeking the death penalty. Standard plea for a death penalty case, especially since they're not cutting any deals. They're not interested in cutting deals. They want to put this dude on the slab, and that's it. Period. Claremont County is not fucking around. So they are just a freight train of vengeance right now, getting justice. And I can't say that makes me uncomfortable in any way, shape, or form. Yeah, I just hope that we get some answers. I'm not one of these people. I cannot relate to those of you, and I don't fault a lot of you for it, but I can't relate to the attitude of I don't need to know the why, just fucking kill him. I'd like to know a motive. I'd like to know some sort of sense to be made out of this if possible, but if not, yep, jab the needle in him and send him out to the Almighty for judgment. Is what it is. I'm not going to shed one tear. But I am very, very curious. Now, as much as I hate the fact that this is going to trial, as much as I hate the idea of this, these three boys' loved ones having to relive any trauma, as much as I hate the wheels of justice turning that much slower, because there's going to be a trial. It is definitely going to be an interesting trial, to say the least. I believe that this will be an interesting trial, because I'm just dying to know what kind of defense this guy thinks he's going to come up with. It's either going to be a very interesting trial, but it'll probably not be. It'll probably be just really open and shut. The guy's just trying to just exercise his instinct for survival. He's going to have a public defender. Chances are his public defender is just going to do the bare minimum, kind of like Letitia's attorneys did. So we'll probably see the bare minimum from the defense, and it'll probably just run just right through, and this trial will be over in a matter of a couple of weeks tops. That's what I'm predicting. Not a couple of weeks from now, but a couple of weeks from when the trial starts. That's my prediction, but we'll see. That's just my uneducated guess. And that's where I'm at on this. But of course, any updates that happen between now and July 5th, you will get here. I'm going to be staying on top of this case and following every detail of it that is obviously plausible, verifiable. Any updates that are verifiable, I'm going to share with you guys. And of course, we do not deal in rumors or irresponsible speculation here based on rumors or hearsay. We just don't do that. Anyways, guys, I am going to wrap this up. I love you guys very, very much. You guys are amazing. Thank you guys for all the support. Thanks for all the likes. And thanks for logging on, period. We will do this again very soon, my friends.